The Supreme Court of the United States just issued a unanimous 9-0 decision that cracks open one of the most powerful shields in American law, qualified immunity. For decades, when police used force, especially deadly force, many lawsuits ended at the courthouse door because of a narrow legal test. But that test just got overturned. Whether you're a gun owner, a law enforcement professional, or simply concerned about civil liberties, this one matters. Because it changes how every encounter with law enforcement will be judged in court. Stick with me, because we're breaking it down. What changed, why it matters, and what you should know going forward. On screen text or CTA overlay, comment below. Should all of an officer's tactics be considered in court? Yes or no? Chapter 1: What happened in Barnes v. Felix. Let's start with the facts. In April 2016, a traffic stop in Houston, Texas, led to tragedy. A man named Ashtian Barnes was pulled over for unpaid toll violations in a rental car. During that stop, Officer Roberto Felix, JRB, ordered Barnes out of his vehicle. Then things escalated. Barnes tried to drive away. Felix jumped onto the door sill of the car, hung on as it moved, and then fired 2 shots. Barnes died. The lower courts applied a standard known as the moment of threat rule, meaning they look only at the instant when the officer perceived the threat. Because Felix was on the car and the door was moving, the judgment was that he reasonably perceived danger, and the shooting was lawful under that narrow lens. But the Supreme Court said, not so fast. They reviewed the case, and on May 15, 2025, they issued a unanimous opinion rejecting that narrow approach. They held that courts must look at the totality of the circumstances, including how the stop started, how the officer handled it, what the suspect did or did not do, not just the brief moment when shots were fired. So Barnes isn't just another case of a tragic stop gone wrong. It's the vehicle for a major legal shift. Supreme Court 3 Legal Information Institute 2. Chapter 2, The Old Rule. Moment of threat, and why it failed. To understand the importance of this ruling, we must go back a bit. Historically, when courts looked at police use of force under the Fourth Amendment, they used a standard set in cases like Tennessee v. Garner 1985 and Graham v. Connor 1989. The key question: was the officer's use of force objectively reasonable from the perspective of a reasonable officer on the scene? But in several circuits, including the Fifth Circuit, a doctrine developed, the moment of threat rule. Under that rule, courts would look only at the exact instant when the officer perceived the threat that caused the shooting, ignoring the events leading up to that moment. Why was that a problem? Because it created what many critics call snap judgment immunity. If an officer found himself in a threatening scenario, however, he got into it, the court would stop the analysis at the split-second moment and give the officer immunity. The earlier decisions, actions, or poor tactics, even if they escalated the risk, were excluded. That led to 2 major risks. Legal Information Institute +1 Congress.gov 1 Avoidable tragedies. Courts couldn't account for how poor decisions earlier in the encounter contributed to the final outcome. Lack of accountability. Officers could be shielded from lawsuits even when the lead-up involved questionable tactics, simply because the final moment looked dangerous. In short, the law sometimes rewarded tunnel vision rather than full context. So Barnes isn't just another case of a tragic stop gone wrong. It's the vehicle for a major legal shift. Supreme Court 3 Legal Information Institute 2. Chapter 3 The New Standard, Totality of the Circumstances. So what changed with Barnes v. Felix? The Supreme Court made 3 significant clarifications. First, no more artificial time box. The court rejected the moment of threat doctrine entirely. It said courts must consider all the relevant circumstances, including the facts and events that led up to the final act of force. Second, no perfect hindsight. The test remains what a reasonable officer would have perceived at the time, not second-guessing with 20/20's hindsight. But that reasonable officer must have access to the context the officer actually had. Third, officer decisions matter, not just suspect conduct. The court made clear that pre-force choices by the officer positioning, commands, escalation are relevant if they created or increased the danger. The suspect's earlier conduct remains relevant too. To quote the opinion, a court may not review the totality of the circumstances if it has put on chronological blinders. In practice, this means when a use of force claim comes up under 1983 civil rights law, the courtroom is going to see a much fuller story. Not just, what did the officer see in the last instant, but also, what caused the situation to get to that instant? And that has huge implications for both plaintiffs' civil suits and defendants' officers and departments. Legal Information Institute. Tell me 1 Sandberg Phoenixegal Information Institute. Chapter 4, Why This Matters for Qualified Immunity and Gun Owners. Now, we get to the core of why your audience must care, especially if you're a lawful gun owner, or you defend the rights of gun owners. Qualified immunity is the doctrine that shields government officials, including police officers, from civil liability unless their conduct violated clearly established law. Until now, many cases ended early because courts focused narrowly on the moment of threat and said the officer's split-second reaction was reasonable. With the new totality standard, courts will reopen more cases previously dismissed under the narrower rule. Police 1 Your lawful carry, your disclosure, your compliance, they now count as part of the full context. Suppose you inform an officer, "I'm licensed to carry," and then follow instructions. Under the old rule, the final split-second mistake could erase that. Under the new rule, your earlier actions are relevant. For law enforcement, your tactics, commands, positioning now matter in court. If an officer boxed someone in, gave conflicting commands, or escalated the situation, those decisions will be part of the jury's view. For gun owners who ever believe they may be confronted by officers, it means you should ensure your actions are clear, visible, deliberate, because your actions will now become part of the story they analyze. This decision doesn't mean every shooting is unlawful. It means that every shooting will be judged under a more complete lens. And for gun owners, that's a key shift, because too many tragedies began with lawful carriers who were misinterpreted or mishandled during an encounter. This ruling gives their side of the story a chance in court. Chapter 5, Practical Takeaways. What citizens and officers should do. Let's break this down into actionable steps for gun owners and for officers. For gun owners, citizens, if you are carrying and stopped, disclose early if required by your state law. Keep your hands visible, move slowly, and narrate your actions. Officer, I'm licensed to carry. I have my permit in my left wallet. I will reach slowly with my left hand now. Avoid sudden movements, especially reaching for pockets without instruction. Under the new standard, your earlier actions matter. Know your state law. Do you have to declare your carry? How should the officer proceed? Being prepared helps create a clearer context for courts later. For officers' departments, body cams and dash cams must capture the whole encounter, not just the last few seconds before the shooting. Training and policy must reflect that earlier decisions are relevant. Commands, affirm, clarity. Avoid overlapping orders, ambiguous language. Consider how a reasonable person would perceive your instructions. Positioning and tactics, an officer's choices leading to force will now be examined. Approaches that escalate or corner someone may show up in court. For both sides, documentation matters. Clear reports that include the timeline, positioning, lighting, commands, and movements will become key. Courts will see more cases. What used to be summary judgment dismissals may now move forward to full trials, because the new rule demands broader factual inquiry. In short, if you interact with law enforcement either side of the badge, this decision changes the stakes. It turns the final moment into a chapter in a story, not the entire story. In a story, not the entire story. Closing and call to action. The unanimous decision in Barnes v. Felix signals one thing: the era of ignoring the lead-up is over. The full context now counts. If you carry, if you serve, if you care about rights under the 4th or 2nd Amendment, you need to know this. Drop a comment below. Do you think this decision will lead to greater accountability, or will it hamper officer decision-making? I'll respond to the first 100 comments. If you found this breakdown valuable, hit subscribe and ring the bell. We'll continue tracking how this ruling plays out in real cases, especially in gun law contexts. Stay informed, stay sharp, stay free.